So that takes us back to today's purpose, which is to look at the Children's Care and Justice Act in a little bit more detail. And what we're hoping to do is to summarise some of the content of the Act, what sort of things you should be thinking about in terms of your practice, and then pose them some questions of where that might take us over the next wee while. And to do that, we've got my colleague Debbie Nolan, who, like myself, is a practice development advisor at CYCJ, and she leads on the implementation of the Children's Care and Justice Act at the CYCJ end with my support. But prior to that, she was seconded from CYCJ to the Scottish Government, where she was involved in the Children's Care and Justice Bill team. So really knows the Act, the Bill and Act really well from the inside and now from the implementation end. So Debbie's going to provide a summary of the content for about 35 to 40 minutes, after which we'll have time for some Q&As. So I'm going to pass you over to Debbie, and please do use the chat function for any questions that you might want. Over to you, Debbie.
Great, Ross, thanks very much, and thanks everyone for joining us today. Obviously a lot of interest in today's webinar, which is fab, and it's great to have you guys along. So as Ross has mentioned, the focus of today is really to raise awareness of some of the provisions within the Act. We know that different people will have different levels of awareness of the Act, so either it will be some new information to you or a bit of a recap on what the provisions of the Act are. Throughout today, and I suppose a big part of the focus of today is really to encourage you guys to think about, what does this Act mean for you, what does it mean for your organisation, and what might you need to do to get ready to act for the Act coming into force. We're to do that. We've been asked quite a lot of questions from people about how are different people approaching this, where should we start. So we're going to highlight a little bit about the approaches being taken across Scotland in preparing for the Act coming, and we'll touch on the support that CYCJ can provide in doing that. So before we do that, I think it would be useful just to touch on the aims of the Act. And I think what's really important is that as much as the Act is now became an Act earlier this year, the commencement of the Act has begun and will be done on a phased basis over the next will happen over the next 18 months. The aims of the Act and the development of the Act far predates this, I suppose. So the bill itself took about 2 years of development, but actually a lot of it came prior to that. And the aims of the Act have really remained consistent throughout. So I suppose one of the core aims of the Act, as much as the Act does not specifically make reference to this, the core aim of the Act, I suppose, is that we are still avoiding formal interventions for children where they are not required. And that is consistent with the minimum intervention principle. It recognises that there's real risks of inappropriate system contact with children. So what the Act kind of builds from that foundation of we're keeping children out of formal systems if they don't have to be there. However, what the Act does do is that where children do require support or intervention of formal systems, that is available through the children's hearing system. It addresses that anomaly at the moment where 16, 17-year-olds have limited routes to the children's hearing system by enabling all children under the age of 18 who require compulsory measures of care or could require compulsory measures of care will now have a route to the children's hearing system where they did not before. And what's really important is that the Act is not just about children in conflict with the law. So that change will be for all children under the age of 18. So where the children have care or welfare concerns or are in conflict with the law, there will now be a route to the children's hearing system for those children. So that was the first aim of the Act. The second aim of the Act is that where children do come into contact with the criminal justice system, and through the raising of the age of referral to the principal reporter, we do anticipate more children will have their cases dealt with through the children's hearing system. However, the Lord Advocate and Procurator Fiscals will retain the discretion to begin criminal proceedings in respect of children and to prosecute children. So for those children who do still have their cases dealt with and their needs addressed within the criminal justice system, we need to make sure that our approaches to those children are trauma-informed, rights-based and are age and stage appropriate. So the Act makes a range of changes in respect of that. Where children do need to be deprived of their liberty, and the Act is I think, fairly clear that actually the deprivation of liberty should be the option of last resort, which is consistent with UNCRC, United Nations Convention on the Rights of the Child, which has recently been incorporated into Scots law. So what we should be doing is considering all possible alternatives to prevent children being deprived of their liberty unless they absolutely have to be, because we know that is a really significant decision for children and interferes with one of their most significant and primary rights. But where children do need to be deprived of their liberty, so for those few children who need to be deprived of their liberty to keep themselves or other people safe, this should only happen in age-appropriate care facilities. And as Ross has mentioned, that will be achieved and has been achieved by ending the use of young offenders institutions for children in Scotland. The Act then fourthly makes provisions in respect of cross-border placements. This is where children are placed from other jurisdictions in the UK into Scotland for care-based placements. And whilst those decisions will have usually been made by courts or services out with Scotland, meaning there is some limited jurisdiction that Scotland can have over the legal basis of those placements, these placements should only be occurring in exceptional circumstances where it's in the best interest of the individual child. And the promise was crystal clear about that. So what that does is it introduces additional safeguards and regulations in respect to those placements. And then lastly, the final aim of the Act, which is linked to the raising of the age of referral to the principal reporter, is to enhance the provisions in respect of people who have been harmed. So where a child's case is referred to the reporter, where the children's hearing system is going to be dealing with a child's case, we need to ensure that people who have been harmed, including other children who we know are most often victims of other children, they need to make sure that there is enhancements to the information and support for those children. So what I would stress is that as much as there is I think there is broad welcoming of the Act, broad welcoming that this is the direction of travel that Scotland has been on. This will help us to keep the promise. It will really reinforce and cement getting it right for every child. It will help us meet our obligations under UNCRC, and it is consistent with the general direction of travel in respect of recognising children under 18 as children in terms of child protection guidance, for example, and this whole raft of other policy developments that the Act builds on. I think people are really welcoming of this and welcoming of the legislative change. There is an element of anxiety for people about what will this actually mean in practice? What will this mean? Will this mean more children are coming within statutory systems or formal systems? How and where will children be supported? Will that change, for example? And some concerns, obviously, in the current context where we know there's real resource pressures, we know there's a whole raft of different developments taking place and high levels of demands and needs. But what I would stress is that these foundations are there, and the Act really extends and equalises the position of 16 and 17-year-olds and extends all of these foundations that already shape your practice that in the context that's already taken place. That's not to say that this isn't going to result in change, because there will be elements of change that come from this. But I think it's really important for people to remember this is building on what you're already doing and the work that's already taken place. So what does the Act actually do then? And there are 8 different parts of the Act, so we're not going to be able to go into all of them today. As Sally has put in the chat, there's a link to an information sheet that we've published which goes into some level of greater detail about the different elements of the Act, and we intend to publish a range of briefings and run further webinars as the provisions of the Act get ready to go live to give people more information on that. But today, to give some of the broad headlines of what the Act actually does. So firstly, the Act amends the definition of a child to reflect that a child is anyone under the age of 18, as is consistent with UNCRC. The way that the Act does that is by, firstly, changing the definition of a child under children's hearings legislation. So that means that a child can be referred to the children's hearing system under the age of 18 if they meet the referral criteria. Previously, there was this sort of limited routes for 16, 17-year-olds, and the Act addresses that. To streamline that, the Act also amends the definition of a child in criminal justice legislation, which means that by and large, in criminal justice legislation, a child will be defined as under the age of 18. And it also makes a parallel change so that where a child is a victim of a Schedule 1 offence, a child is defined as being under the age of 18, and also updates the definition of a child in antisocial behaviour legislation to 18. So across those pieces of legislation, the definition of a child will be streamlined as someone who's under the age of 18. In addition to that, the Act builds on transitional support to young people, so trying to avoid this cliff edge of children no longer getting the support that they require as they turn 18, for example. So the ways that the Act does that, I suppose, is through this enhanced definition of a child, we may see more children becoming looked after children, which in turn could mean more children having aftercare entitlements. So there would be more transitional support through that. In addition, there is build on the existing requirements that where a panel is terminating a child's order, they need to think about the supervision and guidance that a child may need beyond their order, and that is increased to a maximum age of 19. So we may well have panels on terminating an order saying this child still needs supervision and guidance, and the local authority would have a duty to provide that. And then finally, for our children who are placed into secure care, having been remanded or sentenced, those children now need to be treated as if they were a looked after child. So for the duration of their stay in secure care, those children will have aftercare and will have corporate parenting entitlements. There will be statutory duties to support and review those children and their cases as you would be doing for any other looked after child, but also potentially those children could have aftercare entitlements as well. So really trying to reinforce a child is anyone under the age of 18 and to strengthen the support that's available to children as they become young people and as they turn 18. In terms of the changes, the raising of the age of referral to the principal reporter, so now all children under the age of 18 who meet the referral criteria could be referred to the children's hearing system. There are some changes made to what the children's hearing system can do. Fundamentally, the measures and types of orders that can be made by the children's hearing system have not been changed. However, some of the measures that can be attached to those orders have been slightly amended. So firstly, there is a focus on prohibitions. So the children's hearing system can, for example, place a condition on a child's order that a child can't go to certain places, can't contact or approach certain people, for example. Secondly, at the moment, the movement restriction condition criteria and the secure care criteria are the same. And what the Act does is separates those two criteria out. So what that means is that it tries to reinforce that a movement restriction condition is a high level of order, it's high intensity and is highly restrictive, but it is a restriction on a child's liberty, whereas secure care is a deprivation of liberty. So therefore, what that Act does is it makes some changes to those two, it separates them out and then makes some changes to those criteria. By and large, the focus is still about the child's risk of harm to self or others in terms of secure care, but there is in both of those measures a move away from the language and notion of the child being at risk of causing injury to someone else to focus on physical or psychological harm, recognising that injury might be associated solely with physical harm. And then finally, through the children's hearing system, there is an extension of the information and support to people who've been harmed. So in terms of information, there is a clarity that people will have a right to request information if they have been harmed from the reporter, where a reporter is dealing with a child's case. They will also extend the information that could be shared as part of the reporter's decision making, but there will still be exceptions to that. There will still be case by case decision making, but there is a much greater emphasis on the information that might be needed for victim safety planning. And there will also be a focus on a single point of contact being made available so that all people who have been harmed will be able to access, have a route to access support if they have been harmed. So some changes to the children's hearing system, but very mindful of the fact that there was the full review being done of the children's hearing system, Hearings for Children report, and the changes that might come in terms of the children's hearing system. itself, but some changes are made to the children's hearing system, as have been outlined. In addition, there are some changes made in respect of the approaches to children in the criminal justice system. So as Ross has mentioned, the use of young offence institutions for children in Scotland has been ended. So children under the age of 18 who need to be deprived of their liberty, having been remanded or sentenced, would now be placed in secure care. There are some enhanced safeguards for children in police custody and court processes. So at the moment, where a child aged 16, 17 is not known or on a children's hearing order, their treatment is different to what it would be as if they were a child in police custody, and what the Act tries to do is bring that up so that those safeguards are in place for all children. So that's things like making sure someone is notified that any child under the age of 18 is in police custody, put a greater emphasis on the need for social work to visit those children while they're in police custody, the inability of children under the age of 18 to waive solicitor access if they've been interviewed by the police, and also a greater focus on not bringing children into and not keeping children in police custody. And if a child, for example, needs to be kept somewhere pending an appearance at court, that an alternative place of safety should be being considered and pursued as far as possible. Likewise, in terms of court processes, at the moment, there are some differences between court processes depending on whether the child is under 16, the child's 16, 17, and the types of legal process that the child's going through. And what the Act tries to do is put a greater ability to consider when should court cases be taking place, where should they be taking place, who should be present, and really a greater emphasis on the ability to consider closed courts for children under the age of 18. What's also really important is, for all cases, courts will need to consider what could be done to enhance the child's participation in court processes. And this is critically important because the promise was really clear. Traditional adult court processes are not places where children's rights can be upheld. So there is a real strengthening on the consideration of safeguards for children when they end up in the justice system. The disposals that are available to court for children are not fundamentally changed, but what is strengthened is the ability to remit a child's case back to the children's hearing system when they have pled or been found guilty. So again, some changes to the criminal justice system, some changes to children's approaches, really to try to reinforce and uphold the safeguards and rights that children have when they end up in that system. The kind of fourth key area relates to secure care, and there is an update to the purpose and definition of secure care in the Act. What that means is that it makes really crystal clear that secure care is about deprivation of children's liberty, but in doing so, care, education and support that's trauma-informed needs to be provided. And as people will know, there can be real challenges in securing secure transport for children in Scotland. So that's where a child has needs for their own safety or for other safety, or because they've been remanded or sentenced, they have to be transported in secure vehicles. And what the Act does is requires ministers to set standards for that provision, and for those standards need to be complied with by secure transport providers and those who commission secure transport. As I mentioned, the Act also strengthens the regulation around about cross-border placements. So for the provision of cross-border placements, there's an emphasis on outcomes and standards being set, but also that Scottish ministers can treat children placed on orders where it appears to correspond to a CSO. They can have greater powers to regulate those orders. So that can be putting greater requirements on the child's home local authority to do certain things, and there can be consequences if that's not fulfilled, but also requiring those placement providers to do certain things. That really recognises that when children are placed considerable distances from home, there is a real need to give some additional considerations as to how those children's rights will be upheld. And then lastly, the Act repeals the provisions of the Children and Young People Scotland Act 2014 around about child's plans and named persons. Those were already operating on a non-statutory basis, but I think it's just important to flag that should still continue. So those named person and child's planning processes still continue, but do so on a non-statutory basis. It's now just taken out of the legislation. And really critically, Scottish ministers need to review the Act every year, review the operation of the Act, and they need to report to Parliament on that. as part of that review, they need to be thinking about, is there sufficient resources for the implementation of the Act? So I think that's really critical and should help us to avoid a situation where parts of the Act are not commenced, for example, owing to lack of resource. So that is in a nutshell what the Act does. Obviously, we can provide far more details on those individual parts of the Act, and we will, as I say, intend to do further briefings, further webinars as these different parts of the Act go live. And on that note, so as I said, the Act became an Act in June, and one part of the Act commenced on the 16th of July, which is about where a decision to prosecute a child does not appear to have been done compatibly with UNCRC. There is the ability to reconsider that, bringing that prosecution in a compatible way. And that happened when the UNCRC Incorporation Act came in. So that part's already live. The other part that's already live is about the ending of YOIs. That commenced at the end of August, and that part is already live. We anticipate later this year that Scottish Government will provide a timeline for commencement, and what that will mean is that we will know when the remaining parts of the Act are going to commence. What we do know is that in June, the Scottish Government will need to report to Parliament on the operation of the Act. And what we do know and what we do anticipate is that by the end of this parliamentary term, so by April 2026, the remaining provisions of the Act should commence. So what I think would be helpful is to be thinking about is that in the next 18 months, we can anticipate all of these provisions going live. So we now have an 18-month window to start thinking about what do we need to do to get ready for these provisions commencing. And people are really now, I think, focusing on this, and it's brought it kind of starkly into people's attention to be thinking about, okay, what does this mean and what does this mean for me? So one of the key questions we keep being asked is, where should we start? And I suppose there's no easy answer to that. I think in some ways, start anywhere. There will be lots of different ways of planning for the Act coming. There will also be lots of different implications of the Act, which will vary depend on who your agency is, what your agency does, and how your agency is currently set up, and what you are currently doing to meet the needs of children in your area. So different approaches are being taken by different agencies. So in some statutory agencies, they will have legislation implementation teams, they will have legislation review groups, and they have looked at, what does the Act mean for us? They're assessing impact, and they already have existing approaches and strategies of what they do to get ready for commencement and new pieces of legislation being implemented. However, I recognise local authorities often will not have that. So in local authority areas, there will tend to be kind of 32 different ways of approaching this. But what we know, and we've been in contact with almost all of the local authorities in Scotland to have conversations about the Act, to provide inputs and have discussions about the Act coming. And the way most local authorities are approaching it is, in the first instance, thinking about, where is this work going to sit? Where is our preparation of the Act going to take place? And what are the governance and structures that are going to have oversight of this? So what areas tend to be doing is either situating this activity in preparation for the Act coming under either the Child Protection Committees, Child Protection subgroups, or people are sitting under their Promise activity and Promise subgroups that people have set up, or under their Youth Justice steering groups, Youth Justice improvement groups. What I would say is it's important, if that's where this sits, that's absolutely fine, but it's important just to caveat that the Act is beyond children in conflict with the law. So you need to be thinking about how are we making sure our other children are being adequately thought about what this might mean for them, if the focus is on a youth justice approach. And then finally, some areas are setting this under their structures for children's services planning and children's services arrangements. So I think what people are doing in the first instance is really thinking, okay, where is this work going to sit? Identify a home for it. That's the first job. Then what people tend to be doing is having an initial awareness raising session with that supporting structure. So whichever group this is sitting under, go into that group and giving people information about what does the Act do. Because you can't ask people to be thinking about what will this mean for us if people don't know what's in the Act. So by and large, what people have been doing is a very similar input to what we've just provided today. People have been either themselves, at times through resources that CYCJ have given them, or through their own resources, have been developing something to raise awareness and understanding of the Act. And we are also happy to facilitate that and happy to share resources with you guys that could help you to do that. So that initial awareness raising, people are then thinking about, okay, some of the kind of broad questions that people are considering is then about, okay, this is what the Act says. Some of our key headline questions we need to think about is what might be the implications of this change for our service structures? So where are 16, 17-year-olds being supported at the moment? How are they being supported? How are their needs being met? How are we doing that across the continuum of services, right away from early intervention, right up to managing our kids whose behaviour present at high risk and maybe are subject to care and risk management processes, for example? Where are we situating this? How are those children being supported now? How are we meeting their needs? How well are we doing that? And how will those needs be supported in the future? So some of the key questions people are asking themselves is about what are the implications for that, for service structures, for supports, for our processes, for our guidelines. People are then thinking about what support will our workforce need to do this, what staff development might people need, and how can we meet those needs? Can we meet them internally? Is this about sharing skills, knowledge, understanding, experience across, for example, child protection services and children and family services, and also our adult justice colleagues? Is it about sharing learning and understanding across justice and children and family service? Is it about us setting up arrangements for joint working cases, for example? Thinking about who will take ownership and governance of this work over the next 18 months and beyond, and also then really critically thinking about who else needs to be involved. We can't track this on our own, so who are our key partners, how are they involved, and who needs to be involved? So those tend to be the very initial questions that people seem to be asking themselves, and that we would be encouraging people to ask themselves. However, what we know is there's also more detailed questions that people are thinking. So often the approach that areas are taking is they are having this initial awareness raising, having this initial kind of consideration, key questions on the slide that came previously, but then people are drilling down much more into the different parts of the Act and are thinking about, okay, what is the impact of this? What are we already doing? What are our foundations we've got that we can build upon? What are our new developments that we're already doing? And then from that, thinking about what else do we need to do? What actions do we need to take? How are we going to take them? Who are we going to take them? When are we going to do them? What might be our barriers? What might be our supports? What might be our coordinated activity? And then thinking about what do we already know and how will we know going forward? So what data do we have? What evidence do we have? How do we get the views of children and young people? And how will we monitor and be alert to any unintended consequences? So really moving from that initial stuff to this kind of deeper dive information. And these different bubbles that are on the slide are things that through the resource and implementation group from the Act have been identified as things that might need focus and attention. So your supports and services, what are you already provided? What else might need to be provided? How might that need to change? What about staffing and personnel? Recognising that recruitment and retention can be really challenging for people. What might our workforce need? But also what information and competence raising might be needed across the multi-agency partners, but also what information might children and families need, for example. Spoke about service structures, but also what might be our practice and cultural change here, and how are we going to support each other to do that. The recognition of children as children under the age of 18 will be challenging for some people, and how do we support people on that journey? And then thinking about what are our processes, what's our guidance, what is our policies that frame and shape our practice that we might need to think about. And then from that, what people are or what we would encourage, I suppose, is that through those dialogues, through those conversations, some areas are having workshops to do this, some areas are doing it just as part of their improvement groups or whatever their supporting structure is. Then from that, you should be getting the bones of an action plan, the bones of what are the things we need to do over the next 18 months and how are we going to do it. And then it's a case of acting on that and taking action to prepare for that change coming. That is kind of local domain. That is the local elements to it. However, what we know is the local is shaped by the national, and there is some parts of the Act that will need national multi-agency activity, that will need guidance, for example, that will need preparation undertaken. So as I've mentioned, we have an implementation and resource group for the Act that has been meeting for, I think, over 2 years now throughout the bill's development. They have been able to identify a range of needs related to different parts of the Act, as highlighted on the last slide. However, there are already a range of supporting structures in place. So there's the Children's Hearings Improvement Partnership. What we have considered is there's lots of different subgroups under that. Could some of them be kind of refocused to look at the national parts that need to be done to support the implementation of the Act? We then have the Youth Justice Improvement Board, which already has these groups sitting under it. So the Advancing the Whole System Approach Implementation Group, which Ross leads, they will look at the remittal parts of the Act and what work might need to be done under that. But there is also an intention to set up a workforce development subgroup, which will be wider than the Act, but we'll think about what might the workforce need to plan for these changes and the wider changes that are coming. Some of the things, for example, that people have already identified is about what is the difference now between children's hearings and court reports? What different things need to be included in them? How can we upskill people in writing those reports? Things like movement restriction conditions. What actually does the workforce need to know about them, and what could they look like? Other things that people have identified is in respect of children at court, for example. What support can be provided there? In addition to that, there's also the Children's Rights Implementation Group, and underneath that we've set up a Children's Rights at Court group, which will look at both the provisions of the Act in respect of children at court and how they can be made a reality, but we'll also look at wider issues around about children's rights at court. And then lastly, there's a Trauma-Informed Pathways group set up, which will look at the issue of children in police custody, and will be very much focused on the Act and the parts of the Act with that, but we'll be looking at the use of police custody for children more broadly, recognising that there is really a collective aim that we need to have fewer children in police custody for shorter periods of time. There is also a National Secure Care group that meets, and under that group there is the opportunity to set up other supporting structures or subgroups that could take work forward, for example about secure transport. There is already a fortnightly group that meets about the ending the use of YYs, and that could also feed into that group. And there is also discussions about under the age of criminal responsibility. There's been a community confidence subgroup which has looked at what information do communities need about the changes that are coming, and we're thinking about where might the Act fit with that going forward. So we've touched on the Act, we've touched on where to begin and how are people approaching getting ready for the Act coming. We've touched on some of the national level parts. So what can CYCJ do to support, and what are we already doing? So from this we've identified 5 key areas where we think we can help people. So the first is about agency readiness. So that's the stuff that I've already spoken about. We have got the recorded webinars, we've got all these different inputs that we can provide, we've got slides. We are very happy to share materials, we're very happy to speak to you guys about what would help. We're very happy to help you facilitate things, workshops, inputs, whatever else. We've also got a bit of an informal network of contacts for the Act, and we would be happy if anyone wants to be kept updated on the Act, if anyone thinks they've kind of got a lead role in the Act, for them to notify us and we can share information with you as that becomes available. We have given consideration to whether that should be a more kind of formal network, but we're still kind of considering that. So happy to help and support people to get ready for this change coming. recognising that what this means will vary locally. We're also keeping in touch with the range of kind of national level agencies who have got roles and responsibilities here, so police, Children's Reporters Administration, Children's Hearing Scotland, Scottish Courts and Tribunals, for example, and trying to keep a handle on, at a national level, who's doing what in respect of this as well, to try to work out where other gaps might be or where multi-agency responses might be needed. We're also doing a lot of awareness raising, so blogs, information sheets, briefing papers, webinars like this. We've also got a webinar planned in early next year with Celsius, which will look at the Act in respect of child protection and what the bearings and implications for that might be, and we're planning on continuing to host them. We've also updated our practice guidance that's available on our website, which I think is 16 chapters of different information for practitioners, and that reflects the Act. And we've also updated that and are in the process of updating that to reflect the changes of the Act, and that will be kept updated. And we're also looking at our online resources like the Child's Journey, and we're in the process of updating that to reflect the changes of the Act as well. What I would say, however, is other things that you think we could do in terms of awareness raising, in terms of support, get in touch, because we're super happy to explore and make our offer as helpful as it can be to you guys doing this on the ground. The third area is about practice development support. So we already offer our practice development service, so people get in touch with us about case-specific queries or general queries related to children in conflict with law or the Act itself. We are getting a lot of them, so if you have questions, queries, get in touch with us. From them, we try to give you, the individual who's contacted us, as best information as we can, but we're also constantly thinking about what are the themes that's coming through that, what more can we do, what can we do to fill some of those gaps. So some of the things at the moment, for example, that we're looking at is how can we pull together more information about secure transport, for example, because we're getting a lot of queries about that. How can we get an agreed process about transitions from secure care to young offenders institutions, for example. And we're also particularly focused on early and effective intervention, because we know the success of the Act is going to heavily rely on making sure that early and effective intervention is available to all 16, 17-year-olds. We're also thinking about alternatives to deprivation of liberty, because we don't want children placed in secure care if they don't have to be. So we've published a practice guide chapter on that. We're looking at more guidance on that, and in the future looking at more workarounds about movement restriction conditions. We're also looking at child protection and what does the fit with child protection in the Act mean, and also care and risk management approaches, and also focused on the ending of the use of YYs. The fourth area we're quite focused on is about monitoring and reporting. So there'll be known consequences of the Act, but there'll also be unknown consequences. And we also need to keep thinking about how we'll know from children and young people's experience that this change is having the desired effect. So we're working on that as well. And then lastly, we're working with the Scottish Government around that policy and legislative development, and also supporting those national structures. So I think that hopefully has gave people a bit of an overview. Hopefully there's some questions coming. So I'll just stop sharing my screen and we'll be able to move into that.
That's great, Debbie. Thank you very much for your input. And please, everybody, you'll see in the chat and on the screen the email addresses and websites. If you can get in touch with myself or Debbie or Karen and Joanne that I've suggested in the chat about various different issues relating to the Act and other pieces of work going forward. Debbie, there's a couple of points raised within the chat that I wondered if you could maybe respond to. Maybe offer some clarity around about the scenario of a 16-year-old who does not have a history of being involved in the children's hearing system. Then post 16, they are remanded to court. And I know this isn't in place yet, but when fully enacted, this is going to have implications on their access to leaving care resources, their status of looked after and accommodated child. Can you maybe expand a little bit on that for us?
Yeah, absolutely. So we might have, so if the child has not been known to services previously, by virtue of being remanded or sentenced, yes, absolutely, that child should be treated as if they were a looked after child. If that child then leaves leave secure care on or after their 16th birthday, then yes, that child would have the same statutory entitlements to aftercare as any other child would. So yeah, that would be the case, that those entitlements should be in place.
That's great, Debbie. Thanks for that. And if other people could stick in other questions within the chat as we're going along, that would be great. We've got a question that I'm sure chimes with issues that are going on around the country just now, and it's regarding the length of time that children are in court just now, and it's not clear exactly what the position is from Procurator Fiscal with regards to opposing bail or not. The question being, is there any discussion taking place around about the Act or elsewhere that might have an impact upon the length of time that people or children are waiting in cells, waiting to be dealt with, and also the knock-on impact that has on local authorities in terms of transport, placements, and so on and so forth?
Yeah, absolutely. We are hearing this from different areas. There is ongoing discussions with partners about this, so discussions with SCTS and COPFS, Scottish Courts and Tribunal Service and Crown Office, about that. Part of the challenge, I think, is that where a decision is being made regarding the opposing of bail, that can often involve a range of partners being part of that decision-making process and gathering information from a range of partners, which means it can take considerable periods of time for that decision to be raised and that decision to be made, and then in turn the decision being made by the court. That is being looked at and is being discussed, and as soon as we could provide any further information on that, we will certainly do that. So it is being looked at, it is being discussed. We appreciate that there is at the moment some challenges around about whose roles and responsibilities is it when children are, for example, in cells for periods of time or being held for a court appearance. And we are also doing some work at the moment with partners around about trying to get real clarity as to roles and responsibilities there. So that is a big area of focus around about the Children's Rights at Court group and the Children's Rights Implementation group. So it is an area of focus there. In terms of the if a child is potentially going to be remanded, what we would be encouraging is that contact is made with the secure care centres as soon as possible. So there is care inspectorate guidance on matching guidance that already exists. It is in the process of being updated and is due to be published relatively soon. And what that care inspectorate guidance looks at is what information should local authorities be providing secure care providers with to help them make a decision in terms of accepting a referral for a child. What we know is that can be really challenging when it's a remand, because the child might not be known to services and the timescales that you're talking about may be quite short. However, that gives some further guidance on, you really want to share and be trying to gather as much information from that child while they're at court as you possibly can to be informing your referral to the secure care centre. The other part is about secure transport there. So consideration when you think a child's at risk of remand, consideration should be given to contacting secure transport providers to try to get provisional bookings for secure transport. That will involve potentially resource considerations, but I think it's weighing that up about, do we provisionally book something that we might not need, or do we have a child having a lengthy delay potentially for a court transport to be made available for that child when a decision is made to remand them. So recognise that it's a challenging area, recognise that there's issues, are trying to work with partners to get those issues ironed out and addressed as far as possible, but very keen for people to keep flagging those issues with us as and when they arise.
Yeah, thanks, Debbie. I can just add to that particularly Debbie and Ruby Whitelaw at CYCJ are kind of focusing on the secure care transport side of things. So issues like that do flag up, please, as well as contact CYCJ more broadly, please make sure that Debbie and Ruby's aware of that. There's also a list of different providers that are delivering secure care transport that we can send out to people. In fact, we'll send it out to everybody that signed up for today's event. It gives you a list of web addresses and phone numbers and emails, I think, so that it may help with the process, because I know there have been challenges in securing provision at times. and that may respond to the question we have in the chat there, Debbie, about what services are providing transport for children from court to secure accommodation. So most of it will be carried out by Brixton or GWAME in some cases, but there are other providers that might be available. And I've noted your question or comment there, Brian. I'm just waiting for further details about what you were meaning by that, and we'll come to that point in a minute. Whilst we're waiting for more questions to come in, Debbie, maybe I'll reflect on something you were saying earlier, but our next webinar is probably going to be around about the overlap between child protection, what impact the Act is going to have. Is there anything any more you can say about that just now?
So no, I think we're thinking that will be early in the new year. What I would say is we've done quite a lot of input to child protection committees, and we've actually had a really responsive approach from child protection committees, which I think is really important, because as much the care parts of the Act are as important as the justice parts of the Act, and we know that children don't neatly fit into kind of one or the other. So the intention is that will be a webinar that we will run and record later this year, and that recording will be made available so that child protection services locally can make that webinar more widely available as part of their learning and development and as part of their offer.
Great, David. And you said later on this year, I think you mean academic year, maybe January.
Yes, January, February time, but as soon as the date's agreed, we will let you guys know that.
Great. And the best way to hear about that would be either keep checking that webinar link that Sally put in the chat, or to sign up to the CYCJ mailing list. We've got another question here from Margaret McIntyre. She's suggesting that she's agreeing rather with the emphasis on early intervention. And is there anything more you can say about early intervention and how that's going to be affected by the Children's Care and Justice Act?
Okay, a really important point, Margaret, and I think what we know from the recent children's services research that was completed by Celsus, we know that preventive and early intervention services have been, quite challenged. I think what we'd say is that the Act specifically doesn't reference them. However, I think what we know is the success of the Act will be about the parts that sit round about it. So there was a recent survey done, and I know Karen was on the call. There was a recent survey done of early and effective intervention across the 32 local authorities. And what that survey identified was areas for development. I think what's really important is for areas to be thinking about and making sure all 16, 17-year-olds can access early and effective intervention. We don't want to see an expansion of children inappropriately being referred to the children's reporter, because what we know is that when children are inappropriately referred or prematurely brought into contact with formal systems when they don't need to be, we know that has negative implications and negative outcomes. So our early intervention and preventive services are going to be really important here. What I think it's really important to stress is that the children's hearing system for 16, 17-year-olds is being added as part of the menu of options. That means it is just an option. There may well be other means whereby children can be more appropriately supported, be that including through early intervention and preventive measures. So I think early intervention is going to be really important for this, to make sure that we're making sure that children are getting the right support when they need it through the right means. So it's not something that the Act will directly makes specification regarding, but it is something that I think will be really important for the success of the other parts of the Act and to prevent children being prematurely brought into systems when they don't need to be. The survey is not in the public domain at the moment, but my understanding is that there is intention for the write-up of that survey to be published, and there will also be work undertaken to try to look at what needs to come on the back of that. So, for example, some of the key themes I think related to how children's rights are upheld in early and effective intervention processes, how are children informed, how are children participating, things like what is the offer, and how effectively is that offer meeting the needs of 16, 17-year-olds. What it would be really good is there is the EEI Practitioners Forum as well, which is where a lot of that work has come from and has been concentrated from. So, Margaret, that might be something that you or a colleague is interested in being part of as well.
Thanks, Debbie. And just to add to that, if you're interested in finding out more about the survey that was done around about EEI, please contact our colleague Karen Suzek. Her email address is already in the chat if you scroll up. She leads the Children's Rights Implementation Group, but also did a piece of work for the Advancing the Whole System Approach Implementation Group that looked at the role of EEI. What we also did through the Advancing the Whole System Approach is to look at the delivery of EEI and other supports for across the whole system approach for 16, 17-year-olds, which sort of said that there are unfortunately gaps in our provision and delivery of EEI for that cohort. And that's something that we collectively need to address, because unless we have active functioning EEI services covering the whole country, the Scottish Children's Report Administration is going to get inundated with lots of referrals that might not necessarily meet the need for compulsion, but are being used as because the option of going to court, quite rightly, isn't available. So Margaret, please do get in touch with myself and Karen and Debbie to chat about that further. And the EEI Practitioners Forum sounds like a great place for you to be raising these issues. Debbie, I know we've only got 5 more minutes, but I was wondering if you've had time to read the comments from Brian in the chat there, just to summarise them. It was a child that was appearing in court, unknown, the risk of them being remanded. They secured a secure placement. Unfortunately, he was liberated in any case. But in the process of doing that, there was a bit of dispute as to who had responsibility for managing that issue. I think one of the major points here was that the child was from out with the area. The court was out with the area. It's a child from local authority A who was appearing in a court within local authority B. Is there any agreed position on that, or any thoughts on that issue that would be highlighted? Okay,
thanks. That's a helpful point, and it's not the first time that this has been raised. So what I would say is that in that situation, in all likelihood, so the police, where that child is being held and is going to be either released on an undertaking or is going to be held in police custody to appear at court, Police Scotland have given a commitment to notifying the local authority of that situation. So the local authority should know that that child is either being released on an undertaking or held pending an appearance at court. So that should be a first point of notification. That notification should go to the child's home local authority. So where the child lives at the moment, the child then should be known. So i.e. not the court area, the place where the child lives. The second part then is that the second area of notification would be then the court-based social work should be gaining an understanding of that child appearing at court. If it becomes clear to them that that child does not live in their home local area, what would ordinarily happen would be contact between the court-based social work and the child's home area to notify them that the child was appearing at court. There would usually then be a discussion about who was going to support that child at court on that particular day, but the predominant responsibility for providing information, for organising a secure placement, for secure transport, for example, would sit with the child's home local authority. So the home local authority would be responsible for providing that support. They would be the one that, if the child did get remanded, they would need to organise the transport for remand, their remand placement, and the Scottish Government would fund the remand placement. They would need to liaise with Scottish Government to inform them of that, which is detailed in the briefing paper. But when that child then became a looked after child, treated as a looked after child, it would be the child's home local authority that would be responsible for that process. So there should be dialogue and liaison between the two different areas, but the fundamental responsibilities for that child would lie with the child's home local authority.
Thank you, David. And a follow-up question, would that apply if the child is from the north of England, for example? That's a great question. So yes, in that situation, I think you would be the response. Well, it's a good question. It's a tricky one because the legislation would be Scottish legislation. I think what you would want to do, you would need to be liaising with the child's home area in that situation. My view would be that it would be the home local area who would still be the one that would be responsible for that child's case. But that's one I need to give some more consideration to, and we can come back on that one. Yeah, please, Maria, please do get in touch with Debbie with that one. Please do not involve me. That's a far too tricky. And the very last question on and a pretty straightforward one, Debbie. I'm pretty sure this is easy to answer. Lisa is asking about the awareness of sheriffs and court staff, and whether or not there's anything to be done in that area. They're aware of some sheriffs not being aware of the legislation and also taking decisions based on piece of legislation that have not yet been enacted. Is there anything local authorities can do, or is there anything that CYCJ can be doing to respond to that need?
Yeah, so there's a couple of bits on that. Guidance has gone out to SCTS staff, COPFS staff, and also there has been input to the judiciary regarding the changes of the Act in terms of the ending of YOIs. In addition to that, there is, so on the ending of YOIs, I think there is a general across the board element of uncertainty as to what does this mean for that the parts that haven't commenced. So we've heard reporters, for example, now getting referrals for unknown kids who are 17 and they can't accept them at the moment. So there is an important message, I think, for all of us to keep communicating about what parts of the Act have commenced and what parts haven't. So there has been input to the judiciary, SCTS, COPFS. However, that's not to say that there's not more work to be done round about that. I think when you're considering this as local partners, you really want to be making sure that those other partners are involved and are part of these conversations and part of your planning for the Act commencing. So I think there is a national bit that's been done. That national bit will continue. And if you're having these issues, keep flagging them with us so we can then have evidence to say to our partner organisations, look, some more is needed on this. We are also hoping, as CYCJ, to provide some input to the judiciary regarding the Act. We're currently working through a few different things. So, for example, different remand routes before we will look to that. But that is something we are intending to do as well.
That's great. Thank you, Debbie. And thank you for everybody for coming along. I think we'll wrap up there. I'm sure you've got lots of other things to be doing with your time. Please, as I said, do look out for the next e-bulletin, which will have more details about the future webinars. And as we said, there's one January, February next year, which will specifically look at the role of child protection and what impact this Act has had. In the meantime, thanks very much for coming along, and we'll see you later. Thanks.